First is a point that I did make at opening, but to some extent I want to remake it, but just to emphasise it, was the initial point that I made, you might recall, was to say, well, here the payment is not made at the expense of OVL. And I addressed it very briefly in opening, and there's a risk that it could be viewed as just a sort of throwaway point. I want to be clear, it's not in any sense a throwaway argument. It's clear, for example, from investment trust companies and many other cases, that in order to have a claim in unjust enrichment restitution, it has to be at the expense of well, the claimant. My Lord will know there are innumerable academic articles on exactly what that constitutes, and it's a point that we could debate probably for 2 days just on its own. Here in my submission, in circumstances where OVL did not have any beneficial entitlement to the money while it was in the capital account, there would be a strong argument that the payment was not made at OVL's expense. So I just want to emphasise that it is a very real and very serious point. I have only addressed it briefly. I haven't obviously dealt with it fully. That is in part a function of the fact that the restitution issue has just never really been at the fore of this case. And it's obviously not the basis of the Upper Tribunal decision that I've been seeking to set aside. But it is a point that's there. If we have to debate this point again on another day, then it is a point that we would rely on. But the other reason that I haven't really focused on it is because in my submission, my second point, and all the passages that I took you from Goff and Jones are in my submission a clear answer in this case. So I fully accept the proposition that in a standard guarantee case, the paying guarantor obtains a claim against the primary debtor. And that is, as I've outlined, a freestanding claim in restitution. But in my submission, this is not, and is not even close to, a standard guarantee case. And one way of testing that is to say, well, here, the parties could have chosen to make this a standard guarantee case. We do have a guarantee. They could have all just stood on the boilerplate co-op guarantee with no capital account deed. But here, in addition to the guarantee, we have that bespoke agreement between all of the parties that as my Lady Justice Falk pointed out yesterday, does cover all withdrawals from the capital account, and that's clause 3.6.2. And in my submission, that agreement, that bespoke agreement, exhaustively provides what will happen in respect of withdrawals from the capital account. And you have my submission that if the parties had intended a withdrawal under 3.5.3 to have some effect and to generate some liability on the part of the LLP to OVL, they would have.
This is your exclusio unias point, isn't it?
Well, it's well, no, it's a slightly different point, my lord. It is in the context of the contract, but here it's saying that operates to exclude any claim in restitution.
Yeah.
And the point here is that, just stepping back, big picture, restitutionary claims really operate in the gaps between contracts, where a contract's failed or where the contract hasn't provided for a particular scenario. But here, that isn't the case. We have a contract, bespoke, well-drafted agreement governing the capital account. So in my submission, there's just no scope for the law of restitution to work its way in here. Yeah. And indeed, it must not do so, because if it did so, it would fundamentally rewrite the contractual bargain that the parties who entered into the capital account deed agreed. So on that point, I would obviously commend the analysis that I took you to in Goff and Jones, the particular paragraphs that I took you to in opening. Those paragraphs make clear that where the parties have contractually agreed the position, that is the answer that the court will look to, rather than looking to any default position about under the law of restitution. And just one point there, in my submission, my learned friend can't get around that by saying, well, they haven't agreed the position in respect of 3.5.3, because that's really just to go back to the contractual argument that we've already dealt with. Once you've construed the contract and said, no, the contract doesn't provide for anything in the context of 3.5.3, and that shows that they didn't intend to provide for anything, you can't then subvert that finding or that analysis by then saying, oh, well, we can still get there in the law of restitution.
So the point is that 3.5.1 tells you what happens.
Yes.
And 3.5.4 tells you what happens. Therefore, the silence of 5.3 is telling you that nothing is there.
That's the objective intention of the parties, yes, my lord. My lord, then the final point that I need to make is to address the document that my Lady Justice Falk asked about, which is the LLP into creditor deed. Now, I have to say at the outset, my lady's instincts were unerring. It is a relevant document in this context. I didn't address you on it in opening, so I am actually going to have to show you the provisions if the court will indulge me. Now, in doing that, there's a slight logistical difficulty in that, my lord, I think you're working from a hard copy. Is that right? My lady, are you working from the email?
I can't remember quite what I was saying. I'm happy to work from anything that we've got. Has it been put in hard copy?
There's a hard copy where it's just because the email sent last night has all three of the intercreditor deeds, so it's a 50-page document.
I don't know. I haven't had enough time to see what differences there are between them, if any. They all look very similar.
They're all based on what seems to be the same template, but there are differences. Fundamentally, one is dealing with the liabilities of OVL. One is dealing with the liabilities of the OPCO. We don't need to look at that one. And
the one that I've got in front of me in hard copy
is the LLP.
Is EF page number 3713.
Yeah, that's the one we need to look at. That's the only one I need to look at. The OPCO one is irrelevant. This is the one that...
Just tell me where we need to go. Was it sent in hard copy?
It should be on your desk, my lady.
Okay, it is. I've got a copy.
It's stapled, I think, and it says intercreditor deed relating to the liabilities of London Luton BPRA to OVL and the bank. No. I've got a spare here if that would help.
But I might need that. Oh, I found something.
3713.
London Luton BPRA to OVL and the bank. 3713.
3713. Well, if we're all working off the same hard copy, that does make it easier. So, just to give some context, yes, my lord, there are these three documents. One relates to the LLP's liabilities, one relates to OVL's liabilities, and one relates to OPCO's liabilities. OVL's liabilities is the developer intercreditor deed that you've looked at in some detail, particularly in the context of issue 1. We don't need to go back to that. The OPCO one is irrelevant. So it's only the LLP intercreditor deed I'm looking at now, which was the document that my lady asked about. It is a deed regulating all the liabilities of the LLP, specifically those to the bank, co-op, and to OVL. You'll see on page 3173, front page, as with all the intercreditor deeds, as with the developer intercreditor deed, it's between the same three parties, so OVL, co-op, and LLP. If we go a couple of pages on, we've got the definitions section. And a few of those definitions we just need to look at. The first is the top one, bank liabilities. That means all liabilities arising under or in connection with the finance documents to the bank, and all other liabilities now or hereafter due, owing, or incurred to the bank by the LLP in any manner whatsoever. So basically all liabilities of the LLP to the bank. We then have there's a definition of the facility agreement, and that is the co-op loan. We then have a definition of liabilities. That means all present and future sums, liabilities, and obligations payable or owing by the LLP, whether actual or contingent jointly or severally or otherwise, howsoever. So that's all liabilities of the LLP.
I would have expected finance documents to be defined somehow, but I can't see it.
It's defined in the co-op loan.
Ah.
I think that the way it works is the co-op loan is, in effect, the sort of primary document. These intercreditor deeds essentially sort of sit below that if you were drawing a structure of it all. We then have, well, it looks a bit like DVL, but it's not. It's OVL facility agreement. That is the developer loan.
Yeah.
We then have OVL liabilities. That means all liabilities arising under or in connection with the OVL facility agreement to OVL, and all other liabilities now or hereafter due, owing, or incurred to OVL by the LLP in any manner whatsoever. So here, all liabilities of LLP to OVL. And then just to note, finally, the OVL security documents. It's a slightly confusing label to use because when we look at it, it means the second ranking fixed charge over the property together with any other document entered into by the LLP, creating or expressed to create any security over all or part of its assets in respect of the OVL liabilities. So that's called the OVL securities. It's things that the LLP has entered into to secure its liabilities to OVL. So, for example, it wouldn't include the guarantee because the guarantee is something that the OVL has entered into. In terms of the operative provisions, if we could turn over to page 3717. Clause 2.1, regulation of claims. The bank and OVL agree to regulate their claims in respect of the liabilities as to subordination and priority in the manner set out in this deed. So liabilities is all liabilities of the LLP. And then,
sorry, just to note 1.4, this refers to the definitions in the facility agreement.
yes, my lady. That's very helpful. And I think most of the agreements do incorporate those definitions. 2.2, London Luton BPRA, so the LLP, enters into this deed for the purpose of acknowledging and agreeing the arrangements between the bank and OVL, and none of the undertakings given in this deed are given to the LLP, nor shall be enforceable by it. So this deed is about the position of OVL and LLP as OVL and the co-op as regards the LLP. It's not about any rights of the LLP. We then need to trip over to the next page, clause 5, documentation. In this deed, the OVL facility agreement, which is the developer loan, and the OVL security documents, which are the security arrangements entered into by the LLP, form the entire agreement as to the OVL liabilities. So the entire agreement as to the liabilities of the LLP to OVL. If there's any inconsistency between the terms of this deed and the terms on which the OVL liabilities were incurred by the LLP, the terms of this deed shall prevail. So this deed is, as it sets out, the entire agreement relating to LLPs. Well, sorry, it identifies those three agreements as the entire agreement in respect of the liabilities of the LLP to OVL. In my submission, it's the parties expressly providing that the liabilities of the LLP to OVL shall be and only be those set out in those contracts. One final short clause I need to take you to is on page 3721. Clause 11.3. This deed overrides anything to the contrary in any of the OVL facility agreement, which is the developer loan, or OVL security documents, so securities entered into by the LLP. And then it's 2 pages further on. And this is really the relevant clause for the purposes of the restitution argument. Clause 15.4, until the LLP release date, which is effectively when the LLP's liabilities to the bank are extinguished, OVL will not, by virtue of any payment or performance by it under this deed, be subrogated to any rights, security, or money held, received, or receivable by the bank, or any trustee or agent on its behalf, or be entitled to any right of contribution or indemnity from the LLP. Now, a couple of initial points just to pick up on that. You might notice the heading is a little bit odd, because it says subrogation of London Luton BPRA, and it's not dealing with the position of the LLP at all. It's dealing with the position of OVL, saying OVL won't get a claim in a subrogated right or any claims in restitution. The reason for that, I think, my lord, is a point that you identified, which is that these agreements all come from a template. And if you see, I give you the reference, we can go there if we need to, but there is an equivalent clause 15.4 in the developer intercreditor deed. It's page 152 of tab 3 of the supplementary bundle. And that uses the label subrogation of London Luton BPRA in a way that is meaningful because it's addressing the subrogation and claims of the LLP. But in any event, that heading doesn't matter because, as you perhaps would expect, clause 1.3.1, which is back a few pages in the interpretation section on page 3716, says in this deed, headings are for reference purposes only and shall not affect the construction of anything in this deed. So when the heading does seem to be a mislabeling, but it's of no importance. So, my Lord, in my submission, this clause is to some extent the final piece in the jigsaw. It does make clear in my submission that payment by OVL to the co-op by way of a clause 3.5.3 withdrawal would not lead, quote, to any right of contribution or indemnity from the LLP, which is exactly the type of restitutionary claims we're...
Well, yes, until the release date, which is defined as when the bank is paid off.
In full, yes, yes, indeed, my lady.
So it doesn't preclude some sort of right arising at that point.
Not until, it doesn't, no, not until after the loan has been paid in full. So once the 7 million loan has been discharged.
Yes.
But in my submission, that would, in a sense, that would always come after any withdrawal from the capital amount under 3.5.3.
Indeed.
Now, just to, there's one point I should address. An argument could be made to say, well, would a withdrawal under 3.5.3 be something done under the deed, under this deed? It does say, by virtue of any payment or performance by it under this deed. My submission, yes, 3.5.3 would be a payment made under the deed. As we've seen, this deed regulates all the liabilities of the LLP to OVL and the bank. So all of those liabilities are in effect under this deed. So a clause 3.5.3 withdrawal is a payment by OVL made under the deed, i.e. within the scope of. What clause 15.4 does not provide or require is a payment or performance pursuant to this deed or expressly under a power or provision in the deed.
But is there any positive obligation contained in the deed to make payments?
Not really, my lord, no. And that's why I say what this is talking about is, in effect, liabilities that fall within the scope of the deed.
Yeah. Right.
And so what I would submit, my lord, is that on any view, this provision is entirely consistent with and supportive of HMRC's construction of clause 3.5 of the capital account deed.
Yes.
And it in a sense, it explains, taken together with clause 3.5, it explains why there aren't any such words in 3.5.3. Because the parties have expressly, they have expressly excluded any claim in restitution. So the idea that, well, the parties were just leaving it to a guarantee-based claim, I can't stand in the light of that. So all we're left with is, in my submission, the capital account deed. And that's why I say it's the final piece of the jigsaw. I mean, in my submission, the capital account deed, you have my submission on this, but the capital account deed is sufficient on its own for all of the reasons set out in the Goff and Jones. So we don't need that. We don't need this clause. So if the clause didn't exist in my submission, we'd still get home on the basis of the capital account deed. But what this serves to do is to confirm that HMRC's analysis of clause 3.5 is correct. As I set out before the short adjournment, then, it doesn't appear to be disputed that if clause 3.5.3 works the way that I've said it does, it doesn't seem to be disputed that in that scenario, BPRA would not be available because of the possibility of the money just disappearing out of the loop. And in my submission, that is exactly the position that does arise. So it must follow that BPRA is not available in respect of the capital amount. Yeah. And I'd simply add, in conclusion, that there's no reason for the court to be be reluctant to come to that conclusion, because for all the reasons I set out in the context of the commerciality of the arrangement, the effect of so finding would simply be to deny relief in respect of one aspect of the development that the FTT rightly identified after a long hearing of the facts as being artificial, as it said, circular and self-cancelling. It is in effect just a mechanism bolted on to the development. My Lord, if I could just have a moment to check. My Lord, unless I can assist further, those are my submissions.
Thank you very much.
Grateful, my Lord.
Yes.
My Lord, my ladies, I'm going to advance my reply submissions under 5 headings or topics. Topics 1, 2 and 3 concern the legislation. Topic 4 relates to the IFA and promoter fees, and topic 5 concerns the franchise costs. I'm not going to respond to everything my learned friends said in their submissions, and I maintain what I submitted in opening. As regards the first topic, this relates to the definition of qualifying business premises. Yesterday, my learned friend Mr. Bremner described my criticisms of the Upper Tribunal's incorrect interpretation of qualifying business premises as misplaced. That's yesterday's transcript, pages 149 to 151. My learned friend's submission was one needs to look at the Upper Tribunal's decision as a whole. I agree with that. What we have in the decision, in my submission, looked at as a whole, is a very clear error in the Upper Tribunal's understanding of what is needed to qualify for relief. And that error goes to the core of the Upper Tribunal's identification of the purpose and context of the legislation, the importance of which was recognised by the Upper Tribunal at paragraph 148. The error is one which the Upper Tribunal repeated time and time again on pages 202 to 203, paragraphs 151, 153, 154, 155 and 157. Notwithstanding how fundamental this point is, my learned friend suggested I was nitpicking and that those repeated errors are nothing to worry about, because on 3 occasions, paras 151, 154 and 155, the words available and suitable for letting also appear twice in brackets. My submission is that there are 2 problems with my learned friend's response to this. The first problem is that my learned friend denied that what the Upper Tribunal said in the last sentence of paragraph 151 was wrong.
Well, I think if we're going to look at detailed textual points, we better have the paragraph.
Yes, of course.
151.
151 at page 202.
Yes.
So, my learned friend's submission was that there's no problem with the penultimate and final sentences of 151 because it's being used in his submission as shorthand. That's, in my submission, not a good explanation of what the Upper Tribunal is doing here. It's no good for the Upper Tribunal to recite the wording of the legislation, then say put another way, and then set out an understanding of both the target of the relief and the conditions for qualifying for the relief in a way that makes it totally clear that its understanding of those crucial matters is wrong.
Yeah. You say that what that sentence should say is, put another way, the target of the relief is a converted or renovated building which is a potentially functioning building capable of being open for business and being used as for a trade or an office. That's about right?
And being used or available and capable for letting. My preference, my lord, would be to track the wording of the legislation.
Yes.
Which I believe is what your lordship was putting to me. But the incorrect focus from the UT is on use.
Yes. Yeah, well, you made that point.
You have that submission. But my learned friend submission is, well, don't worry, because slightly earlier in paragraph 151, the Upper Tribunal says something that tracks the wording of the legislation. My point is that the Upper Tribunal does do that, but then it seeks to summarise what it's taking from the wording of the legislation. That's what follows in the sentence. Sentences.
Yeah, put another way,
Indeed.
expresses their understanding.
Indeed. That's my point. And my learned friend also places reliance on the fact that elsewhere, say at paragraph 154, the Upper Tribunal adds in brackets and availability and suitability for use. But Your Lordship has my submission that the insertion of those words in brackets actually means that paragraph 154 doesn't make sense. The second problem with how my learned friend seeks to downplay these errors is that, as we've seen, when the Upper Tribunal comes to apply what it says, paragraphs 151 to 157 in its decision, it makes a clear error of law, as I showed you yesterday, most obviously at paragraph 324, which is at page 240.
Yes.
Where it says the concern of the legislation is in effect the end product, a business that is operating as a business or office. So it's not the case that the Upper Tribunal gets it wrong at 151 and following, and that it's not material. It is material. One sees it form part of its decision. That's my first topic.
Yeah, well, your point again is that the concern of the legislation is indeed the end product, but the end product is not a building which is operating as a building or office.
Indeed. It's the converted or renovated building, which is used or available and suitable for use. And Your Lordship has the submission that the Upper Tribunal's incorrect interpretation of the legislation then infects what it goes on to decide in relation to the franchise costs, the IFA and promoter fees. My second topic relates to clawback. Yesterday, my learned friend Mr. Gammy said that the business at the converted building has to be kept in operation for 7 years to prevent clawback of the relief under section 360H2. That's recorded on the transcript for yesterday at page 94, lines 8 to 14. And specifically, what he said was that if the hotel business is not a viable proposition, then the statutory test of qualifying business premises isn't going to be satisfied. That's not correct. The building either has to be used or it has to be available and suitable for use throughout the period. The businesses or tenants operating businesses from the building can come and go during that period.
So presumably you say that in theory it could just lie empty for the entire 7 years, as long as it was available.
Available and suitable for use, yes. Well, that's in the authorities bundle at page 17, section 360H.
I think you may need to read that with the circumstances.
Yeah, I find myself.
No, I think you have to read that with the balancing adjustment provisions to make sense of your point, don't you, to get to the 7 years.
Indeed, my lady, yes.
So 360M, which is on page 18, section 4 has the more than 7 years point.
Yes.
And then you have to go elsewhere to find.
Next section, 360N tells you what they are.
And the relevant one maybe is 360NF.
Indeed.
Ceases to be qualifying business premises.
Yes, but it won't cease to be qualifying business premises.
So, sorry, just to explain, what was behind my point was that my reading of this, rightly or wrongly, was that to be qualifying business premises, it either has to be in use or available, and provided it is one of those for the 7-year period, allowances aren't clawed back.
Correct.
What's the policy behind making a balancing event the death of the person who incurred the expenditure? What's that all about?
It's a good question, my lord.
Seems odd.
I don't have an answer. If I may turn to my third topic.
Yeah.
I can take this briefly. It's what on covers.
What
On covers.
Yeah. As opposed to in connection.
Indeed. So yesterday my learned friend Mr. Gammy took issue with my submission that in connection with covers things like architects and surveyors fees. That was yesterday's transcript at page 100. He took issue with that because in his submission those things are covered by the on aspect of the test. I'll just make 2 points. First, the submission seems to be based on Benedetto, which is a case involving an on test, albeit a different on test, as my lady Lady Justice Falk, my learned friend, which was found so difficult to apply it went up to the House of Lords. My second point is that during the course of my learned friend's submissions there was some debate about what on covers. And my simple point is the fact of that debate I think supports my submission. If Parliament wants to ensure that things like surveyors' fees and architects' fees and so on qualify, and there's debate as to whether they would qualify based on an on test, that provides a perfect explanation for an honour in connection with test. My fourth topic.
Sorry, can I just put to you an example I put to Mr. Gammy? Suppose that the person who wants to carry out the conversion is refused planning permission and then appeals against the refusal and incurs various expenses in a planning inquiry and gets the permission, enabling the project to go ahead. Would you say that was covered by in connection with?
I'd like to repeat the answer I gave yesterday, which I think your Lordship didn't find very helpful, which is, firstly, it would depend on a close analysis of the
It all
facts,
depends.
and secondly, I need to consult with those behind me, see their facial expressions and so on. I think, my Lord, that sort of fact pattern will need to be tested in due course if need to be. I am going to return to the other example your Lordship put to me yesterday about merchant bank fees.
Yeah.
That helps. Fortunately, there's a day's lag in responding to my Lord's question. My fourth topic relates
I don't always ask easy questions.
My fourth topic relates to the IFA and promoter fees.
Yeah.
I'll address the submissions made in response to my primary case first. I've got 3 points. The first is that my learned friend Mr. Brem advanced a general submission that my appeal on the IFA and promoter fees doesn't raise a point of law. I'll simply say that my submissions endeavoured to signal what I say the errors of law were and why they were errors of law. I'm not going to repeat that. You have my submissions, they're recorded on the transcript. My second point is that my learned friend in his submissions this morning, I think, backed away from the idea that this is a fee for equity investment, described as a cost of raising finance. But the point remains in my submission that these fees are at least one removed from the conversion or renovation of property. That point is particularly acute in relation to the IFA fees, because as my Lord Justice Lewison put to my learned friend Mr. Bremley yesterday, they're paid because the IFAs are advising their client on the best tax shelter to use. It's of course correct, it seems, that the IFA fee is triggered if and when a client goes ahead with a particular tax shelter, but the fee is still referable to the advice. And the promoter fees are intimately connected with the IFA fees because the promoter fee is in relation to the information memorandum which is sent out to the IFAs in order for them to advise. So they're not, in my submission, analogous to bank arrangement fees or the cost of raising finance. My third point relates to my Lord Justice Lewison's question yesterday in relation to the costs of obtaining advice on a share issue. Firstly, I didn't say, as my learned friend sought to suggest, simply that I needed to take instructions. What I said was two things, and the first was that whether such a fee would qualify would depend on the facts, including expert evidence and so on. These points aren't straightforward. They don't lend themselves well to an instinctive answer based on a hypothetical set of facts before a second appeals court. But based on my understanding of the facts that my Lord put to me, and if it would assist me to pin my colours to the mast, my submission is that such expenditure wouldn't qualify because it suffers from similar problems to the IFA and promoter fees. It's a cost of changing the membership of a structure. It's not directly or exclusively connected to what that structure goes on to do. The fees may well be out of kilter with the renovation or conversion costs. There are obvious concerns about layers of fees and possibility of abuse and where one draws the lines and so on. I mean, if fees of that nature qualifies, what would the limit be? A cost of an IPO? Would that qualify? My submission, surely not. One has to make sure that BPRA can't be used as a backdoor to provide relief or subsidise all sorts of activities. It's a renovation relief. It's not a general business relief.
Yeah.
I'll turn now to HMRC's alternative case. I articulated yesterday the important point of principle arising in respect of this. That's recorded on the transcript at pages 36 and 37. Contrary to my learned friend Mr. Brammer's submissions this morning, I'm not quibbling or nitpicking with a matter of evaluative judgment. I'm raising a point of principle. In my submission, my learned friend was driven to recognise this because according to my note of his submissions, he said that I was trying to elevate this to a point of principle, as if he disagreed with that. But the next thing he said about the argument was that's not how this legislation is intended to work or how it does work. Those are questions of principle. It's not about quibbling with matters of fact or evaluative judgment. 2 points are notable from my learned friend's submissions. The first is that we seem to have reached or be on the cusp of reaching acceptance that this is a mixed fund. My learned friend faintly reiterated his point, which found no favour with the Upper Tribunal when it was raised for the first time, which is plainly wrong, which is that some sort of inference should be drawn from the fact that the bank borrowing was secured. So there's no merit or foundation for that whatsoever. We are dealing with a mixed fund. And the second notable point is that my learned friend said apportionment is not how this legislation is intended to work or does work. The court may have been expecting that submission to be developed with one or more reasons. None was forthcoming. What my learned friend did instead was jump to my final point that if one cannot apportion, then the fees can't qualify at all. He described that as an extreme and unjust result, but didn't grapple with the point of principle, which is that on his client's case, the LLP is asking the court to grant relief of 100% in respect of 100% of the fees, which were incurred in part, in his case, to raise money to do things including buy land, in circumstances where Parliament has said you cannot have relief in connection with the acquisition of land. And my learned friend has offered no answers to that. My fifth and final...
So what is your answer then? You have to apportion, and you just have to find the best way you can to do it.
My submission is that one can apportion in this scenario for the reasons that I have outlined. If one cannot do that, which is the view taken by the Upper Tribunal, but which I submit is wrong, if one cannot do that, then it must follow that none of the fees qualify, because the alternative would be 100% qualifies, and then the court is giving relief in connection with the acquisition of land.
Well, as Mr. Bremner says, that it doesn't seem just to deny relief on that part of a mixed fund which does qualify. You say, well, it's equally unjust to allow relief on that part of a mixed fund which doesn't qualify. So the conclusion might be that just as the revenue have to make best of judgment assessments from time to time, inadequate material, but the revenue or the FTT has to do the best it can.
It's my submission that apportionment, if we're in the world where IFN promoter fees do qualify, and you have the situation that we have here, where the fees are referable to a mixed fund, which gets spent on qualifying and non-qualifying expenditure, the right way of dealing with that is to apportion. Because that's in my submission, and in my client's submission, how the legislation is supposed to work. I'm not seeking financially the best outcome, because that would be to wipe everything out. So that's why I'm advancing the apportionment as the appropriate way forward in these circumstances. What I'm saying is that the Upper Tribunal said, well, we can't see a principled way of doing it. And in my submission as well, if they're right about that, the choice is either everything qualifies or nothing qualifies. If everything qualifies, then the court or tribunal would be giving some relief in connection with the acquisition of land, which Parliament has said...
No, I understand that. All I'm suggesting to you is that the logic of your argument means that you can never say that apportionment is impossible, because you must apportion, one way or another.
Yes. Yes, my lord. Yes. I may have been arguing with myself. Yes, my lord. That is correct. My fifth and final topic relates to the franchise costs. Again, I've got 3 points. The first is that my learned friends, Mr. Bremner and Mr. Gammy, set up a straw man, I think on more than one occasion, when they advanced the submission that a hotel business needs things to operate. The transcript references for that for yesterday include pages 92 to 95. The question for this court is not whether the LLP should have done things differently. The court is not being asked to grapple with whether it was a good idea or a bad idea to operate the hotel business under a Ramada Encore hotel brand, nor is the question for this court, what does a hotel business need to operate? The question is simply whether the LLP's expenditure qualifies for BPRA. And it appeared to be implicit in my learned friend's submissions that unless they get allowances on everything for which they have claimed allowances, it follows that none of this could have been done. There could not have been a hotel, and my submission is that that doesn't follow. One can convert a hotel, one can acquire a license for a franchise without that license attracting BPRA. The world will not end if they don't get BPRA on their $15,000 license. And their submissions appear to be drawing on what the Upper Tribunal said, wrongly and without foundation, in paragraph 285, that HMRC's approach to the legislation would, in essence, torpedo the effectiveness of the legislation. And you have my submissions on why that's wrong. That's the first of my 3 points. My second point in relation to the franchise costs relates to the sanguine payment. I just want to make 2 points of detail in relation to this. The first of those points of detail is that this morning my learned friend Mr. Bremner described sanguine as a contractual counterparty. It was not. The argument that sanguine was a contractual counterparty was advanced to the UT, recorded in the UT's decision at 313, and it was rejected by the UT, recorded in the UT's decision at paragraph 316.
Sorry, counterparty of OVL.
Of anyone. There was
Okay.
it wasn't contractual.
There was no contract.
Indeed. Sanguine wanted to be involved in managing the hotel, but it wasn't given the contract. The second point of detail is that my learned friend took issue with the description in our appeal skeleton at paragraph 87 of the payment being referable to the possibility of Canuck and Sanguine working together again in the future. We don't have to go there, but if one looks at the relevant passage in paragraph 87, one can see that that description is a quote from the Upper Tribunal's decision at paragraph 317. My third and final point in relation to the franchise costs is that it's instructive in my submission in testing what my learned friends say about the franchise costs to think about what the position would be if the franchise costs were not bundled into the development sum. If one starts with the Ramada payment, say a property is converted into a hotel, a tenant is found, that tenant is going to operate the hotel as a Ramada Encore. That tenant puts in their tax return and claims BPRA on the franchise fee of $15,000. In my submission, that claim would not have a home. It's clearly not connected or sufficiently connected to the conversion or renovation of the building to qualify. The claim would be to subsidise the tenant's start-up costs of the tenant's business. So it would not qualify for BPRA. The analysis doesn't change because the fee is bundled in with the development sum. I think that was one of the points my Lord Justice Lewison was putting to Mr. Bremner earlier, or related. So if we carry out the same exercise in relation to the sanguine payment, say someone renovates a building, they put in their BPRA claim, they claim BPRA on renovation costs of £6 million, and they put in a claim for BPRA on £250,000, which is a gratuitous payment to someone who hoped to be involved with the future management of the business from that building, but that person wasn't given the job. But that person's a friend of a friend, and so the taxpayer pays them anyway. Again, my submission is that a claim for BPRA on that payment wouldn't get off the ground. It's about paying a sum of money to a friend who wanted to be involved with the future management of the business run from a building.
So can I just go back to what it was that was happening here? I'm looking at UT para 310, page 236, which quotes the FTT's findings. So sanguine was in discussion about the anticipated trading figures, and the provision of advice on layout, design and finishes. Canuck then identifies then hotels as suitable, next word should be managers, and operators for the hotel on completion. So are they running the operating company? We were told, aren't we, there was an operating company which goes to run this hotel under the Ramada brand.
Indeed.
So what are then hotels doing, managing and operating the hotel on completion?
So my understanding is the operating company is just a wholly owned subsidiary of this LLP.
Right.
So then
they employ, do they, then hotels as the people who are actually doing the business?
I believe there's a contract. There's a hotel management agreement
Okay.
between the
Operating company and then hotels. Are then hotels anything to do with Ramada or not?
I don't believe so. So Sanguine wish to be appointed as the hotel manager.
Right.
And they're not given that job.
I follow.
But there's a relationship between Cannock and Sanguine to preserve that working relationship in the view that they Cannock and Sanguine, might work together in the future. This payment is made to smooth that over. So that's where the friend of a friend point comes in. So my submission is that in the scenario that I was just outlining, there wouldn't be a hope of that payment qualifying for business premises renovation allowances. And that analysis is the same, notwithstanding that it's a constituent element of the development.
Yeah.
Can I just turn my back very briefly? Apologies, my lord. Just for your note, at paragraph 102 of the FTT's decision.
FTT?
Yes, page 321, there's a reference to a hotel management agreement between the operating company and hotel.
Thank you.
Those are my submissions in reply, unless.
Right, thank you. That takes us to lunchtime, day 5. Oh no, not quite, Mr. Davey.
My lord, I was just about to say, I hope that we're doing something right, at least in this sense. It was hoped that the hearing would be shorter than listed, and I think we're exactly as you say, we're a day and a half ahead. And this is the last thing that the Revenue needs to address this court on. I'm going to address the court on the licence fee. This is a feature of the structure that Mr. Justice Green and Judge Thomas Scott held was not qualifying expenditure for BPRA purposes. Accordingly, the UT found for the revenue on the point and overturned the FTT's decision to the contrary, UTD Para 271. So the LLP is appealing and the Revenue is responding. In terms of where this can be found, UT's decision, Paras 226 to 271. LLP appeal skeleton, Paras 55 to 64. Revenue respondent skeleton, Paras 32 to 47. In dealing with this ground, I'm going to do two things. First of all, I'm going to look at the Upper Tribunal's decision. Secondly, I'm going to deal with the various points made by the other side, appealing against that decision, and why I say those arguments should be dismissed and the Tribunal's decision upheld. Before I do that, I just want to echo a point made by my learned friend Mr. Brinsmead Stockham in his submissions in relation to the capital account. He referred to that mechanism as an artificial bolt-on. And I say the same description can fairly be given to this feature of it, the interest amount or licence fee mechanism. And it's because the Upper Tribunal considered this an egregious example of that it was pretty scathing in describing the arrangement as clearly a circular and self-cancelling arrangement that had no real discernible commercial purpose. That was Upper Tribunal 257. So, with that said, I'll turn to the Upper Tribunal's decision. I can take this reasonably quickly, I hope, thanks to my learned friend, Mr. Bremner's work on this front. It begins at para 226. Where they introduce the topic and describe it as a clearer case, contrasting the capital account mechanism of circularity and uncommerciality. At 227, they make the point that the licence fee was part of the development sum. They go on to say that OBL was required to pay the sum into a deposit account and then pay it back. At 228, question or query is posited. It may be wondered why the quarterly interest payments were not simply paid by the LLP to the co-op without going first to OBL and then back again. And it notes some possible answers. And at 229, it notes the revenues challenge the idea that this was a commercial arrangement. We then have the facts beginning at 231. The UT works through the facts, and that involves necessarily looking at the contracts. We've dealt with this in detail in our skeleton at paragraphs 32.1 to 32.7. I'm not going to simply repeat all of that, but I will, if I may, flag 4 points. Number 1, this is Upper Tribunal decision para 231. We have the LLP granting the developer a licence. You see that? That's clause 1.1 of Schedule 1 to the developer agreement. Point number 2, this is still within paragraph 231 of the decision. In consideration, the developer is required to pay the licence fee amount on the date hereof to be utilised in payment of a quarterly licence fee equal to each quarter's interest charged to the LLP on the finance obtained. And so on. Point number 3, here we're at paragraph 234. It's as regards the specific deposit account. We know from the intercreditor deed that 1652D, it's 350,000 and it's going into the interest account. And we know from clause 16.9 that OVL could not withdraw any amount from the interest account save to enable the LLP to make interest payments back to the co-op. And then point 4, para 235. Yes, this point I that the withdrawals could only be made to enable the LLP to meet its obligations to the bank is also clear from the licence deposit deed. 5. At paragraphs 237 to 240, possible drafting errors are considered and dismissed. And then at paragraph 241, there's reference to invoices for rent requesting payments. Goes straight to LLP's bank account with the co-op. We then have the Upper Tribunal dealing with the FTT's decision, 242-246. There are 3 points I want to note there. First of all, at 242, we have the UT noting that, quotes, there is little or no analysis of those, i.e. the parties' submissions, and with respect it's unclear what the FTT's conclusions were as to the parties' arguments. Second point, Upper Tribunal Decision 243. The UT makes the point that the FTT disagreed with the revenues contention. The licence fee was excluded by virtue of 360B3, and we'll come back to that. And then third point, Upper Tribunal Decision 244. The Upper Tribunal states that the FTT's main conclusion and reason can be found in a single paragraph, FTT 179, and we'll come back to that. We then have the party submissions dealt with at 247 to 249, and then at 250 and following, through to 271, there's discussion. And the material in that area, paragraphs 250 to 271, is dealt with under 4 heads. Number 1, commerciality. That's paragraph 250 to 257. Number 2, tax neutrality. That's paragraphs 258 to 260. Number 3, was it qualifying expenditure? Paragraphs 261 to 263. And then finally, number 4, the exception in section 360B3A. That's paragraph 264 to 270. Now, the third of those 4, was it qualifying expenditure, can I think be seen as, if you like, an overarching issue or a consequence or conclusion of the other 3. And on that footing, we've got 3 elements. Number 1, commerciality. Number 2, tax neutrality. Number 3, the exception in 360B3A. Those are the elements which the Upper Tribunal saw as underpinning the FTT's decision, and it's under those heads that the LLP seeks to challenge the decision of the UT. So I'm going to work through those 3 topics, if I may. Number 1, commerciality. Number 2, tax neutrality. Number 3, the exception. So in terms of the first of those, commerciality, it's the FTT's decision at 179 which is key, and which the Upper Tribunal rightly identifies it as key. It's quoted within the Upper Tribunal's decision at 244, so if it's simpler to stay with that, one can find it there. Quoted within 244, though we will need to go to the FTT's decision as well in a moment. So 179 of the FTT's decision, quoted at 244 of the Upper Tribunal's decision. I'll let the court read that, please. So that's what it says. It comprises 3 sentences. And at paragraph 250 of the Upper Tribunal's decision, the Upper Tribunal said it found it difficult to discern the basis for that arrangement. That conclusion that it was a commercial arrangement. And then the UT goes on to make a number of points. So this is 250 and following. And I've jotted down 3. Number 1, this is Upper Tribunal Decision 250. The Upper Tribunal rejects the inference which the FTT appears to make earlier in the decision, that just because the parties are not connected in a statutory sense, it follows that any transaction between the parties must be regarded as an arm's length commercial transaction. That's Upper Tribunal Decision 250, rejecting First Tier Tribunal Decision 134. The Upper Tribunal considers that erroneous, an illogical and unjustifiable leap in the reasoning. That's 250. Second point, Upper Tribunal Decision 251. The UT makes the simple, commonsensical point that they cannot discern any credible commercial reason to pay a sum of money to a person who's contractually obliged to return it. I do say that very simple observation is very powerful. Third point, Upper Tribunal decision 252. And this is regarding FTT decision 179 specifically.
We've read it.
So, the Upper Tribunal considers there to be two reasons.
Yeah.
And the Upper Tribunal doesn't think that either of them work. Now, as regards the first of those, which we see the UT reject as a reason at 253, the basic point is that it's self-evident that if someone is going to carry out works of conversion and renovation, then that person needs permission to be on the land. But that observation of the FTT, without more, tells one nothing about how to analyse the licence arrangement. Sorry, it doesn't tell you how to analyse a licence arrangement or provide a basis for the finding of commerciality. To give, I think, what will probably be my last example of the hearing, recently a roofer came to my house. He needed to fix my roof and he needed my permission to get onto the roof. But he couldn't go up there without permission, obviously. The law didn't require me to charge him, and I didn't do so. And indeed, had I put my hand out as he arrived with his ladder and said, "Rick, that will be £500," I think he would have looked at me quizzically and might well have walked away. So yes, you need permission to go onto the land, but it doesn't follow from that that one has to charge a substantial sum of money, in this case £333,000.
And the person who needs permission is actually multi-billed
Well, indeed.
rather than OVL.
Indeed. So that's the short point. Yes, one can't trespass, one needs a licence. It doesn't follow from that that the bill's £250,000 to come onto the land to do the works that you've been asked to do. As Your Lordship rightly points out, it's actually multi-billed.
I mean, if it's not an express term, it must be an implied term of a building contract, I would have thought.
Indeed. So, that's the first point. What about the second sentence of the first tier tribunal's decision at 179? That was that the LLP did not have the funds to meet its obligation to pay interest to the co-op. Well, as the Upper Tribunal rightly recognises at 254, while the LLP did need funds to pay the interest, well, it did not need to transfer the licence fee to OVL in order to get it back. It had the money. As they put it in the final sentence of 254, the LLP had the funds in the first place, and it's quite artificial to suggest that the funds needed to be generated in this circular way. And that really is the nub of the point, if one dwells on it, if I may say so. They did have the money, they handed it one way, and then sent it back the other way. That then leaves the final sentence of paragraph 179. We agree with Mr. Gammy that this was a commercial arrangement, the effect of which was not to increase the tax deduction available to the LLP, as the income it received from the licence fee was taxable. Now, the second half of that sentence, tax deductibility, I'll come on to, is not a basis for the first half of the sentence. And we've already looked at what the FTT has said earlier in 179. So if we just take stock of where we are, the position is that the FTT has made a finding that this is a commercial arrangement, but there's no basis for that finding within 179. The earlier finding, FTD 134, that the parties were not connected in a statutory sense, and therefore any contract between them was a commercial arm's length transaction, has been knocked out by the Upper Tribunal as an error of law. And as to the lead-up within 179, and the paragraphs prior to 179, which I'll come on to in a moment, I say there's no basis, and the UT took the same view. So I say it's exempted reasoning by the UT. How does the LLP challenge it? They make 3 points, and we work through those challenges at paragraphs 42 to 44 of our skeleton. The first point concerns circularity. The way it's put by the LLP in their written submissions and also orally is to say that circularity in itself does not justify refusing to recognise the expenditure that would otherwise qualify. We do say that misses the target. The UT did not find that the circularity of the arrangement in itself justified its decision on the licence fee. But we do know from Tower that circularity is relevant, albeit not determinative.
Well, I think that's exactly what Mr. Bremner accepted this morning.
Indeed. So it wasn't circularity that was the basis, or at least all of the basis of this decision here. What the UT concluded ultimately, to take a phrase from 263 of the decision, is that this was not incurred by the LLP on or in connection with the commercial blush house, however widely the test is interpreted. 263 of the Upper Tribunal's decision. What about the expression self-cancelling? Again, this is used within the Upper Tribunal's decision at 257. Well, what the LLP says is that this essentially is the Upper Tribunal illegitimately resurrecting the incurred argument. I simply say that's not a good point. There's no problem with, as a matter of ordinary language, in describing an arrangement whereby I hand £20 to Mr. Brinsmead Stockham, who then is obliged to hand it straight back to me as self-cancelling. I say there's no difficulty with that as a matter of ordinary language, and the Upper Tribunal decision makes clear on a number of occasions that it's fully aware of the incurred position, i.e. that the point is not in play. Upper Tribunal decision 3, 49 to 50, 165. The third point concerns the UT's finding that the payment has no real discernible commercial purpose, and that finding overturns the contrary conclusion of the FTT. It follows reasoning over a number of paragraphs in 250 to 257. Now, the LLP says this finding was not open to the UT because it did not identify an error of law. Now, we say that's wrong. We've made various points in response in our skeleton. This is at paragraph 44, and I'm going to amplify them a little now, if I may. And in doing so, it'd be grateful if we could turn up the first tier tribunal's decision. Starting at paragraph 172. It's on internal page 343 in the bundle. So if we just run through what the FTT is doing here. Well, 172 says what it says, that this is sometimes called the interest amount, sometimes the licence fee. 173 describes the arrangements. 174 to 6 recites the revenues arguments. 177, the FTT rejects the revenues contention in relation to 360B3. At 178, the FTT recites two arguments on the part of the LLP. And then we get to 179, which we've already looked at.
Yes.
So we've seen what the FTT says, and we can see where they get to. And in the UT's view, in their judgment and in my submission, the FTT's reasoning plainly did go awry because they had reached a conclusion which did not have a basis. In the LLP skeleton and in my learned friend's submissions this morning, this is LLP skeleton 61.3.1, it is said that in describing the licence fee arrangement as commercial, the FTT was making a finding of fact. I say that's incorrect, and therefore the LLP's position on this point starts in the wrong place. What the FTT was doing was positing a conclusion or assessment where, in my submission, the most credible candidate for its basis, by its prior finding of commerciality or assertion of commerciality at 134, has already been knocked out as an error of law by the Upper Tribunal.
That's the connected point.
Yeah.
Yeah.
Now, in a sense, I say that's essentially the end of the matter, but if one wants to unpack it a bit further, then what we have with a finding of commerciality is, if one likes, a value judgment, sometimes referred to as a multifactorial evaluation. And here, putting it shortly, it's one that lacked any basis. That is to say, if FTT 134 has already been kicked out, then all that one's left with, given that we've seen the build up to 179, 171 to 178, there's nothing there. All one's left with is 179 itself, the three sentences that we looked at. And the 2 points made in the UT's judgment and in my submission are irrelevant. They're not a basis for a finding that this was commercial. And that itself is enough of a basis to overturn the finding on appeal. It may be the court doesn't need authority, but if it is needed, a recent case which has made its way into the slim further supplemental bundle is the Morrison case. It's an Upper Tribunal decision. It's a VAT case regarding a decision on whether a particular fruit and nut bar was confectionery. The judgments, recent judgments on multifactorial evaluations have gone through and cutting a lot of pages down to a single sentence. Paragraph 58 of that decision, where the Upper Tribunal gets to, is that, quotes, if it is demonstrated that the FTT ignored a relevant factor, that will be sufficient to constitute an error of law. And flipping it round, corollary of that, if you like, would be if a decision is based on an irrelevant factor. Again, one can interfere with it, and one can see that quoted in a passage at paragraph 44 of the decision.
I think there are some observations to similar effect by Lord Conworth in the Supreme Court in immigration cases where the only appeal lies on fact. He discusses what is an error of fact. What is an error of law, rather.
I've no doubt your lordship is correct. I'd be pretending if I knew the exact case in question. But what I would say is that, I'm happy to go to Morrison if it helps, but what was happening there was that the Revenue was saying that in addition there's a further hurdle. The Crown was saying you've also got to essentially show the decision was somehow perverse. And the Upper Tribunal says no, that's wrong. If you've got a multifactorial evaluation, what you need to show is that it's based on an irrelevant factor. Or it's missed out a relevant factor.
Yeah.
No more, no less.
Discernible flaw in logic is one of the
Yes.
one of the reasons.
And so I do say
maybe in a homelessness case, it's one of those kinds of cases where the only appeal lies on a point of law.
yeah. So I do say that the Upper Tribunal was doing something perfectly orthodox, and it was in a position
Yeah.
to do.
Well, we understand why the Upper Tribunal did what it did, but the essential point that's put against you in oral submission is that what the LLP got for its money was a layoff of the risk of overrun, and that if there were to be such an overrun, then the developer would stump up.
Well, I say that's not a good point. What we're really looking at is how to analyse a dynamic whereby A owes £10 to B, and rather than handing it back to B, hands it to C, who then hands it back. It's as simple as that. And the question is whether this legislation is meant to cater for that sort of very simple bounce back mechanism. I mean, I haven't burdened the court with case law, but the court will know that there is a good deal of case law out there about these sorts of mechanisms in tax scheme cases, where a sum of money goes one way and then simply comes back the other way. I mean, to give one example, there's a case called Acorn Wood, which is a case of Lord Justice, well, Mr. Justice Nugent, as he was sitting in the Upper Tribunal. That was a case about whether there was expenditure owed exclusively for the purposes of the trade. It concerned LLPs involved in the creative industries. And the basic structure, cutting it right down, was that a sum of money goes from LLP to counterparty, call it 100, 20 gets used to do things, 80 sits on deposit and then goes straight back. The question is the 80 part of the expenditure for the purpose of the trade?
Yeah.
The answer is no. Perhaps so it's on the transcript. Paragraph 6 and then 74 to 79 of Acorn Wood. Different legislation, but clear analogies and useful insights, both in relation to why BMBF isn't the answer and in relation to Millett's views on purpose of payers, those sorts of things. So I simply say we're really looking at a fairly old-fashioned bounce-back mechanism and whether it comes within the legislation.
So do you say that the allegation of layoff of risk is irrelevant, or that it doesn't exist, or what?
Well, I must say I don't find the submission an easy one to follow. A sum of money goes over, and it has to come back.
Yes, essentially what they're saying is the interest amount would be sufficient to fund the license fee for, let's say, 18 months. I don't know what the figure is. If the hotel were not completed within 18 months, the license fee does not stop being payable. The interest amount is now exhausted, and so the license fee must now come out of the developer's pocket. Let's assume that the cost overrun account has also been exhausted. That, they say, is commercial, particularly in the light of a project that has been marketed at a fixed price, so that the investors in the LLP will not be called upon to stump up more money in the event that the hotel runs into delays because of what happens to be found on site, let us suppose. And that will all come out of the developer's profit, and therefore, they say, that is the real commercial benefit which the LLP gets out of this license arrangement.
Well,
that's the submission as I understand it.
Indeed. And I say it aligns two different things. The two are logically distinct. First of all, there's a sum of money that goes over. That involves no transfer of risk or incentivization. It always has to come back. And I say that's actually where the analysis stops. So it doesn't offload risk and it doesn't incentivize. The fact that there's then arrangements for what happens thereafter I say that's not the answer to this point. The fact that there's a contractual mechanic which links that to something else that happens in the future does not clothe with commerciality a situation whereby A gives £10 to B to get £10 back.
So effectively what you say is what may or may not happen after the license, after the interest amount is exhausted, doesn't alter the character of the interest amount.
Precisely so.
Right?
So, I say that the Upper Tribunal was perfectly entitled to do what it did, for the reasons that I've already given. I'd also make this point. In trying to shore up the FTT's decision, it's notable that neither in their skeleton argument, nor so far as I could discern in oral submissions, was justification attempted to be based upon what's within 179, or indeed what's anywhere within the decision. What the LLP does is say there's some other evidence out there. It's not even referring to what is in the decision. Now, I say that's an instinctively unattractive submission if the LLP is saying to this court the FTT's decision is unassailable, to try to bolster it by things that weren't in the judgment at all. So I say it's not a great starting point. For what it's worth, we say why in any event the points relied on are not good points, and we deal with that at paragraphs 44.1 to 44.3 of our skeleton. I'll just speak to them very briefly, if I may. There were three. Number one, it was submitted that cogent evidence about arm's length negotiation between developer and Downing had been given by Mr. Lewis and Mr. Tracy. This was paragraph 61.3.1 to point 3 of the skeleton, and also referred to in oral submissions today. Now, 2 points. First of all, you have the revenues overarching point, that it's not correct that there was substantial arm's length negotiations. This was the formula. Second point, in any event, the Upper Tribunal addressed this. This is paragraph 251 of the Upper Tribunal.
Yeah, you've quoted it in your skeleton argument.
Okay. I'll move on. Second point, there was reference to the evidence of the LLP's expert as to what happens in tax incentivised structures.
Mm-hmm.
Court was referred to paragraph 939, referred to page 939 of the supplemental bundle. I'd like to go there briefly, if I may.
Which bundle? 4, is it?
4, yes.
Yes, we were shown this.
Yes, and what I wanted to emphasise is that if one looks at what is being said there, so in particular it's line 15 to 18.
Yeah, it talks about a tax-driven property investment.
Yes, a licence fee which provides a commercial return. Now, my short submission is this is not a commercial return. It's simply handing back the very money that's been handed over. I won't go there, but, and as I say, I think this whole exercise is wrong-headed, trying to delve into the evidence, which wasn't even in the decision in the first place. But if one wants other evidence which fortifies the UT and the revenue's position on this, I will give references to, first of all, the evidence of the LLP's hotel valuation expert, Mr. Harper, who said that he had not seen interest charges for the purchase of land passed on to a developer specifically via licence fee. That is page 935 of the bundle. Internal transcript, page 126, lines 1 to 4. And the evidence of the revenues expert, Mr. Williams, who said that in his experience these arrangements were, quotes, most unusual. That's page 721 of the bundle, para 9.3. The third item that was relied upon, I've already dealt with. It's the incentivisation risk point. So, at all events, I say what the Upper Tribunal did was justified on the basis of what the FTT had done and justified on the basis of the relevant principles. That leaves then just two more points to deal with: the tax neutrality point and then the section 360B3A point. In terms of tax neutrality, what the Upper Tribunal was doing was responding to what was said in the FTT's decision, i.e., it wasn't making a point to bolster its own decision, but stating that it couldn't understand really how where the FTT had got to on supposed tax neutrality really fed into the equation. And ultimately that's paragraph 260 of the Upper Tribunal's decision. And I say they were right to get to where they got to. And finally, section
Can I just understand this tax neutrality point? What the FTT say is that we agree with Mr. Gammy this was commercial, the effect of which was not to increase the tax deduction available to the LLP, as the income it received from the licence fee was taxable. Would I be right in thinking that BPRA is given at 100% of expenditure, but the tax payable on the receipt of rent would be at the marginal income tax, corporation tax rate, whoever is receiving the rent?
I'm going to boldly assert, my lord, that you would be right. And
So,
I'm going to wait to be pelted by those behind me.
So you get more tax relief if you can call it BPRA than if you pay income or corporation tax on the rent. I mean, I may maybe be oversimplifying, but
So far as I understand the position, Your Lordship is not oversimplifying.
so I don't understand this last sentence at all. It isn't tax neutral. It gives them more tax relief than they would otherwise have got.
Yeah. Well, the Upper Tribunal, as I say, couldn't really see. Well, I think A, wasn't sure whether it was right at all, and B, in any event, wasn't really sure where it got to. You'll see the final sentence of 260, I think it is, in the Upper Tribunal's decision. Sorry, second sentence within 260. It is, in our view, reasonably clear that a major factor for investors who decide to invest in such a scheme is the availability of sideways loss relief in year one. It's therefore in their interest for the BPRA claim to be as high as possible. So they certainly, well, they say what they say there, and they reach the view, which I say is the correct view, that this licence fee arrangement needs to be seen against that backdrop.
Yeah.
there may be nuances to add to the exchange that
Right,
Your Lordship and I have just had.
I did oversimplify, yes.
Well, no, and it may well be that I oversimplified in response. Perhaps, if that's material, perhaps we might take a moment and come back shortly.
All right.
So, final point, my Lord, is the third element, which was the section 360B3A point. This is Upper Tribunal decision 264 to 270. Now, the Upper Tribunal know exactly what they're doing, and they say at 270, they make clear at 270 that this is an alternative basis. They don't need this. They've already decided that the FTT decision can't stand, but they say that if they're wrong about that, then this would be another basis on which the FTT decision can't stand.
Is that a reason you support?
I'm sorry?
Is that a reason you support?
It is a reason. It is a reason that I support my Lord. I can deal with this very shortly. So if we see 269 of their decision, the licence fee was paid by the LLP to OVL, at least in part to enable OVL to fund the acquisition of a licence over the land. I won't simply read out the rest of the paragraph, but the court will see what the UT says there.
Yeah.
We say that's correct. 3 points. Section 360B3A does not say that it's limited to the acquisition of rights in or over land by the person who incurred the relevant expenditure. It doesn't say that, and the UT didn't see that one was driven to read it in that way. Second point, which I don't set great store by, but I make it nonetheless, within the FTT's treatment of this point, which is para 177, they articulate the legislation overly narrowly. We can go to it if it's of assistance, but what the FTT say at 177 is that the legislation denies relief on expenditure incurred to obtain an interest in land. To obtain an interest in land. But of course, that's not what the legislation says. The legislation refers to expenditure incurred on or in connection with the acquisition of rights in or over land. So it's a fine point, but the FTT appears to have been thinking about the legislation in an overly narrow way when it reached the conclusion that it did. And then thirdly and finally, I would simply say that at all stages in this litigation, it's been common ground that the conceptual breadth inherent in 360B1 and 360B3 must be the same. It's sometimes said, if the ocean is wide, then so too are the islands upon it. And we say that those exceptions, those islands, need to be read in the same broad way. It can't be that on a connection with is broad when it comes to what qualifies, but narrow when not.
Can I just put perhaps a slightly more orthodox example to you? Suppose that in order to attract a tenant, and let's suppose it's a pre-let maybe, you have to pay a reverse premium. So you've paid the money to help somebody else acquire the interest in land. Is that in or out? Assuming everything else is in.
Sorry, so this is a landlord.
Yeah. Converting a building, needs to get a tenant, and he pays a reverse premium to the tenant, or he pays the tenant's fit-out costs or whatever, but not amounting to fixtures and fittings, not amounting to fixtures. But it's an incentive to get the tenant in.
Well, it's a very good question. which intuitively I don't find easy to
All right.
come back with a straight response on that. I mean, it's a feature of this case. These points are quite knotty if one dwells on them, or at least a number of us have found them.
Yeah,
quite
well,
knotty.
I mean, this particular arrangement is a rather unusual arrangement, shall we say.
Yeah.
But a reverse premium or payment of fit-out costs in lieu of rent-free period, for instance, is rather more common.
Yes, I'm reluctant to say
All
that
right,
needs
well, I
to take
won't press
instructions
for an
on it.
answer, but I leave that question hanging in that case. Right. Anything
My
more?
lord, unless I can assist further, those are the submissions.
Now, I think Mr. Brinsmead Stockham is going to put you right on the answer you gave to me.
In the hot spot. Thank you for that, my lord. I'm grateful. My lord, I think fundamentally the point is that overall, in both scenarios, so the scenario where the LLP just borrows, holds onto the money and pays interest, it gets a deduction for the interest. You get the same overall result in one sense because you end up with a net deduction for an interest cost in the interest account mechanic. What's fundamentally happened, though, is that what would be otherwise a revenue cost, the deduction for interest, has been turned into a capital cost, which can qualify for BPRA. The important point there is that the BPRA relief can be surrendered sideways to investors in a way that the interest deduction can't. So it's not tax neutral in a true sense. There's also a point that...
But the point the FTT made was that the LLP would be paying tax on the rent, or on the licence fee.
That's right, but then but the LLP is also still paying interest. So the amount of the rent is equal to the amount of the interest. So that it's taxable, but in that it falls within UK tax, as it were. But it's an amount that's immediately cancelled out by a deduction for the interest cost. So you're left really with the BPRA relief, which represents the amount of the interest, but that can be surrendered sideways in a way that the straight interest deduction cannot be. So it's not neutral. But as my learned friend also said, what the Upper Tribunal was doing there was actually answering a point the FTT made. It wasn't really using that as a basis for its decision in any event. I'm grateful.
Right. Mr. Bremner.
Obliged. Before I turn to LLP Grant 2, may I just please make 3 very brief points on that new intercredited deed, which
Yes.
for the first time on by my learned friend Mr. Brinsmead Stockham, where reliance was placed upon it, and in particular in relation to clause 15.4, to say that payment by OVN clause 3.5.3 withdrawal scenario would not lead to a contribution. That was the burden of the submission. 3 very short points. 1, the submission begs the question as to the correct construction of the developer loan agreement, which Your Lordship will recall is the focus of Mr. Gammy's submissions yesterday. Point 2, clause 15.4 would apply only if we're looking at payment or performance under this deed. Very difficult to see that the OVL ceding the capital account to co-op in the scenario the learned friend has in mind would be payment or performance under this deed. And third point, in any event, if I'm wrong so far, the most that can be said is that OVL's entitlement would be deferred until the release date as defined in clause 15.4. That essentially is when the bank gets paid. If one looks back at the definitions within clause 1, the London Luton BPRA release date, that's what you'd expect anyway. So none of this in my submission, none of this material in the new document supports HMRC's clause 3.5.3 analysis for that purpose. Just to give the court our position on that new document briefly. Turning then, if I may, to LLP Grant 2 and the interest amount. Just one small point of detail. In the exchanges with my friend Mr. David, there was discussion about it needing to be multi-billed who needed the license. They are identified in the development page 22 within volume 1, so this is schedule 1 to the development agreement. And the license extends.
Sorry, just a minute. Development agreement, yeah.
Schedule 1 at page 22.
Yes.
And the license is paragraph 1. And this is just for completeness. It extends to the contractor.
Yeah.
Thank
you.
Yes, Josh is absolutely right. Multi-building needed it, multi-build got it.
Yes.
Now, I'll deal very briefly in terms of the topics that Mr. Davey went through. Commerciality first. Management relied on the observation at paragraph 250 of the Upper Tribunal's decision to the effect that the first tier had proceeded on the basis that if there was no statutory connection, then the transaction was somehow taken as being at arm's length. That was the lever, the first lever into saying well, there's been an error of law that entitled the Upper Tribunal to intervene. 2 points on this. One, I don't accept the criticism. First of all, if one looks at paragraph 133 and 134
Of FTT.
of FTT, one sees that there are 2 separate points being made by the FTT. Nowhere does the FTT say that simply because one is looking at a set of cells where there is no connection in a statutory sense, then it automatically follows, just for that reason alone, that any transactions between down in the LLP, etc., are to be regarded as being an arm's length transactions. What is said in 134 builds on what was said at 133. So I don't accept the criticism that's made at Upper Tribunal paragraph 250, first of all. But in any event, even if there's something in that criticism, the point about statutory connection simply doesn't feature in FTT 179, which is where the tribunal is dealing with this particular point about the commerciality of the license fee arrangement. And I would just remind the court there is nothing whatever in the FTT decision made following 17 days of hearing. Nothing in the decision that supports the proposition that HMRC succeeded in persuading the FTT that this was a non-commercial deal, either viewed as a whole, or indeed that the interest arrangement was a non-commercial aspect of an otherwise commercial deal. Quite the contrary, the FTT is rejecting the case that HMRC strenuously advanced before it, relying on absence of commerciality. These points were gone through in great detail in written submissions in the FTT. So there's no support in my submission for the approach the Upper Tribunal took, saying while we accept that overall the arrangement was commercial, this bit of it wasn't, and actually there's an inconsistency in that approach on the part of the Upper Tribunal. That's point 1, commerciality. Point 2 was just to touch on the example that Anna Fremster did again about a roofer. I wouldn't charge a roofer a fee to come onto my roof and do some work. I simply say that homely example, it doesn't really assist us with the analysis here. I explained the commercial rationale for this in my opening submission, particularly the laying off of risk. And it's for that reason that when Anna Fremster seeks to characterise this arrangement as being about passing money backwards and forwards, which he did with another homely example. I think it was A pays £10 to B and B pays the £10 back to A. That example is not an accurate one, and not a helpful one for our purposes. It's certainly not a complete one, because it ignores the point, if we extend the example, that B would have to continue paying the money for an unspecified period of time in certain eventualities. Because as I submitted this morning, the arrangement put the developer on risk for overruns. There's been no answer to that at all in the revenues submission. So this is not about money bouncing back, to use learned friends' language. Saying that is only looking this case and the decision in Acorn, to which my learned friend referred, that could be seen as a case of money either coming back or just sitting where it was, but that is not the position here. Third point, on self-cancelling, my learned friend had asserted that there was a difference between the incurred point being closed off to HMRC and what the Upper Tribunal said about self-cancelling. He tried to say, well, they were just using ordinary language. It's a perfectly ordinary use of language to describe this situation as a self-cancelling transaction. But there's no explanation as to how that characterisation of the transaction can be squared with the position that we're in, that the licence fee amount, the 350,000, it must be taken to have been incurred. A case to the contrary is not open to HMRC, having abandoned its appeal on that issue before the Upper Tribunal.
Yeah.
Fourth point, this was a sort of second way in to justify the Upper Tribunal intervening. So the other friend sought to say, well, the finding that this was a commercial arrangement is not a finding of fact, it's a value judgment. I don't accept that. Thing one, it's an inference about what the nature of the transaction was. It wasn't dealing in any sense with the statutory question. But to the extent that we say, well, it's an evaluative judgment, we're not in the territory of Morrison's paragraph 58. We're not looking at relevant and irrelevant considerations. We know. The FTT tells us, I think it's paragraph 6 of the decision, that it looked carefully at all the evidence. And it formed the view, having seen that evidence, that this was a commercial arrangement. As I've said, nothing's been pointed to in terms of error of principle or flaw in the logic or whatever that justifies undermining that conclusion. So in my submission, the FTT was entitled to its decision that this was a commercial arrangement. The FBUT was not entitled to interfere with it. Second topic, very briefly, on tax neutrality, just so Your Lordship has our position in relation to the question that was raised about potentially different rates. The allowances, or the relief in consequence of having the allowances, and any tax charge on the income, they would both be at the marginal rate. 100% is the amount of the allowance that then feeds into the tax computation. We're dealing here with the limited liability partnership, which, when you come to work out the income tax position of investors, is tax transparent. So what we would ultimately be interested in is the marginal rates of investors.
Yeah, and as they're high net worth individuals, it's probably top rate of income tax.
But you would end up with 100% of the income taxed at the marginal rate, 100% of the allowance, but granted relief at the marginal rate.
Oh, I see.
So one ends up, if I can put it this way, they get all of the allowance, they also get all of the income. Tax rates are then applied to that.
I follow.
And so that there are, what one has in mind, if one's looking at the LLP's position, there are two scenarios. There's the arrangement that they actually did, so with a licence fee, where there is on this hypothesis BPRA, there's interest income, and there's an interest deduction. So the deal they actually did, just using figures of 100 for simplicity, suppose there's interest income of 100, there would also be a deduction of 100. There would, on this scenario, be BPRA of 100.
Sorry, you mean licence fee, income, interest expense, and BPRA.
Yeah, that's the arrangement that was actually done,
yes.
Assuming I'm right, that it qualifies for allowances.
Yes.
The comparator is with a scenario where simply the LLP meets the interest costs itself. If we assume the same amount of interest, the comparator there would be interest deduction of 100. And so if I'm right about the marginal rate, you end up in the
Same position.
Yeah. Although you're ignoring tax years here. the point is,
It would depend on the period over which
the interest expense, if you got site-based loss relief for it, it would be in subsequent years,
you would,
apart from a very small accrual.
there could be a tiny difference. That is true. So the revenue's real complaint is about, as they see it, turning of a revenue cost into a capital cost, which is then eligible for allowances. And my simple response to that is the point I made this morning, that one doesn't say they could have done a different deal, therefore we pretend it's revenue, you look at the deal they've actually done. Very short point. It's also a very short point on the last topic, which is the land exception in 360 capital B sub 3 little a. There were 3 points taken. There's a text report on 360B 3A saying, well, it doesn't say that it's limited to the person incurring the expenditure. It was noted in relation to the first tier tribunal where it's also in connection with the acquisition of interest in land, and it was noted that 360 capital B1 and 360 capital B sub 3, the breadth of the concept of in connection with it, so well, that should be the same. None of that meets the point that the object of scrutiny here is the expenditure incurred by the taxpayer. And so my point, which is founded on the scheme and context of the legislation, is that against that background, when one construes 360B3 little a, the exception applies where it is that taxpayer who is acquiring, where the expenditure is on and in connection with the acquisition by that person of an interest in land. Let me just take a slightly fanciful example. On the logic of Milan and Friends case, suppose it's known, because a lot of stress in this case has been placed on knowledge as opposed to contractual obligation, or say it had been said in the development agreement that OVL would use part of the development sum to pay the rent on OVL's own offices. The logic of Milan and Friends case would seem to be that we would then be within the land exception in 360 capital B3A. I mean, there may be a way around that, but the logic of the point certainly seemed to take us that that's a sign the analysis has gone wrong, in my respectful submission. But it's a very short point of construction, ultimately, of subsection A.
So you would say that a reverse premium paid by somebody converting a building in order to attract a tenant would attract BPRA, would not be within the land exception.
So in that example, my submission would be that the correct analysis is if it's just a reverse premium, it would be quite difficult to see how the reverse premium was in connection with the conversion as opposed to in connection with letting the buildings. And the right analysis.
Well, it would be in connection with somebody else's acquisition of land. Oh, I see. You say that it fails to get into subsection 1.
Yeah. Would be the most likely analysis, in which case one doesn't then have to grapple with the exception in 360B3.
Yes, I
Would you like to skip me one moment? Unless I can assist further, those are my submissions in reply.
Thank you. Well, I think everybody's had their say, what they want to say. I understand it. Right, very well done. So, day 3. It will not be a surprise to you to learn that we will reserve our judgments. You will get a draft in the usual way. It comes with a very fierce embargo, which means exactly what it says. The draft judgment can only be distributed to those whose names have been given to the court before we started this appeal, and any breach of the embargo may be treated as a contempt of court. The receipt of the draft is your opportunity to correct our spelling and grammar, but not our reasoning, and not to make new points. We would hope that in the light of the draft judgment you will be able to agree an order disposing of the appeal or appeals, but if you can't, please make short submissions in writing and we will make the order that we consider to be appropriate. Thank you all very much for your very interesting arguments. There's a lot to think about.
Court rise.